Well, hello everyone, and welcome to my first podcast on our crime series. In this series, we will be discussing case facts every Friday on Auntie's Advice channel for women. I will be giving you the facts of each case. It is your job to take the facts and to solve or to it is your job to take the facts of these particular cases and to gather the information, and we will be helping two sisters settle a dispute of guilt or innocence. I'm going to be reading to you straight from the Supreme Court opinion, and on Monday on Auntie's Advice channel for women, we will all gather together. I will give you the opinions of the two sisters, and together we will solve this crime. Okay? I will not be giving you the name of the defendant, just the facts of the case. This is our first podcast, Case Facts. Here are the facts. In this appeal, we affirm that the defendant's conviction for murdering his wife, the drowning, at 7 a.m. on May 14th, 1999. The defendant, a minister, called 911 for emergency assistance. His wife of 30 years lay naked and unconscious in the bathtub. The first persons to respond found her face down in the empty tub. The husband was on his hands and knees, sobbing and asking for help. Two EMTs pulled her out and moved her to a nearby hallway to perform CPR. In their efforts, they became soaked with water. After the ambulance left, the RN, who had assisted in attempts to resuscitate her, offered to take the husband to the hospital. She helped him put on his shoes and his socks. The wife, who was laying in the bathtub, regained some heart activity in the emergency room, but never breathed on her own and never recovered any brain function. She expired on May 15th of 1999 at age 54. The doctor, a forensic pathologist, performed an autopsy the following day. Gastric and blood serum toxicology confirmed the presence of subtherapeutic amounts of two anxiety agents, diazepam and lorazepam, and a sedative oxypam. From the partially digested condition of the tablets, it appeared that could have been taken within 4 hours after her drowning. Also present was a toxic and debilitating level of etemazine, but not a fatal overdose. The level of the drug in her system was enough to render her unconscious. The doctor estimated that she ingested about 20 of those capsules, which could not have been taken accidentally. She drowned because she was incapacitated from the dose. In the doctor's judgment, her death was not natural and not accidental, but from the autopsy alone, he could not resolve whether it was a suicide or a homicide. The investigation. The cause of death was medically unattended. Chief Deputy Sheriff examined and photographed the home where the wife was taken to the hospital. After the wife was taken to the hospital, he then took the husband's statement. The husband said that in keeping up with his morning routine, he left the house for about 10 minutes of prayer and devotion at his church next door. When he returned, he noticed that the hallway floor was wet. He opened the bathroom door and found his wife. He tried to remove her from the tub, but she was too heavy. He drained the water and called for help. Witnesses at the scene recalled that he was not wet or that his knee was only wet. Furthermore, he had no shoes or socks on when the emergency personnel arrived, particular in that he said he had just arrived home from devotions at his church. The deputy on the case learned that the autopsy revealed a large amount of prescription drugs. He asked the Department of Criminal Investigation for assistance. They confirmed that the uh, some kind of medicine, was present in the household. It had been prescribed for her as a sleeping aid. Additionally, they discovered that the husband, the pastor, if you will, had been involved with another woman. When the officers first confronted him about the affair, he denied it, but he soon conceded it was true. The detective later obtained a search warrant for the home and the church office. The officer seized the computer in his office on July 27th of 1999. The family had three adult daughters. These are the daughters that we will be trying to handle or settle this dispute between these two daughters. They knew their father was unhappy in the marriage. He had told one of the daughters that he no longer loved his wife and planned to obtain a divorce after his other daughter's wedding in June. For 6 or 7 years, he repeatedly told his youngest daughter not just that he wanted a divorce, but that he hated his wife and that she was fat and ugly and that she so disgusted him he could not force himself to even touch her. The husband's adulterous affair spanned from 1994 to 1999. It began while he was serving as a pastor in Orleans, Nebraska. Despite efforts to keep it secret, rumors of his illicit relationship with the married woman who served as an elder in the church ultimately prompted his superior to suggest that it would be best for him to find another position at another mofo church. Of course, the husband denied any impropriety to both his superior and his congregation. He persisted in saying that he could not consummate a sexual act because he was impotent. Nonetheless, he relocated his family to Woolsey, South Dakota in July of 1996, where he began as the pastor for the church. There, an appreciative congregation heard the best sermons they had ever had, but the affair still continued. On the pretext of attending counseling or meetings, he and his paramour met in motels in Kansas and Nebraska. He had no sexual performance problems with her. Over the years, they talked about him at some point being single so they could be together. She eventually got a divorce. He was hesitant, though, because a divorce with revelations of an affair and his lies about it could affect his future in the ministry. Finally, she became tired of sneaking around. In January of 1999, she told him their relationship was over. It was time to start seeing other people, she said. But she left open the possibility that if he ever left his wife, they could, quote unquote, could date and see how it went. In the months before the drowning, he continued to talk with her on the telephone 2 or 3 times a week. They were intimate on one more occasion in late February, a week after the funeral of his wife. He tried to reconnect with her. She declined. Rebuffed, he told her that it had not taken her long to betray him. Several curious mishaps occurred in the months before his wife died. One case, a cord had been stretched across the steps to the basement. In reporting the incident, the wife told family members that her husband wanted her to come downstairs. When her foot touched the cord, she sat back on the steps. She recalled that her husband grabbed her shoulder to keep her from falling. Yet she told her daughter, "Somebody tried to kill me." She telephoned her dad, angry that the daughter had learned of the incident. He said he had told his wife not to tell anybody about it because he was going to discuss it with the sheriff. The next day, however, he told his daughter that his wife had stepped on her shoelace. Her husband examined the stairs a few days later. 2 steps down, he saw shavings, like somebody had drilled a hole there, with fresh wood shavings on the carpet. On the other side of the wall, it's like a concrete base. There was a round, I don't want to say hole. There was a place where it looked like something had been glued and then pulled off. There was actually something that appeared around there. On another occasion, the bathroom light was not working. The husband brought in a lamp so that the wife could wash her hair in the bathtub. The lamp fell over. As the wife later recounted it, she believed the dog bumped the lamp, and the husband was there to catch it. Indeed, the husband thought he received an electrical shock in the incident and went to the emergency room for treatment. The doctor admitted him overnight for observation but could find no physical manifestation of electrical shock. The doctor recalled, however, that the husband was extremely anxious, breathing very rapidly, nervous, and he complained about a lot of pain in various parts of his body. A computer specialist with several degrees in computer science examined the contents of the church computer's hard drive. He found that the computer had been used to conduct numerous internet searches on subjects uncannily related to this disquieting incident and to the drowning. Some of these searches were not connectable to any date. Others could be pinpointed to specific dates in the months before his wife's death. His wife had access to the computer, but she was not very familiar with the internet. Her daughter has shown her twice how to use a web browser, but other than sending and receiving emails, she seemed to have little interest in the internet. In the 2 days before the falling lamp episode, the computer in the husband's church office had been used for 2 hours to conduct specific internet searches using an online search engine. The repeated queries were for household accidents and bathtub accidents. On April 15th, 1999, the husband brought his wife to the clinic with the complaint that she could not wake up. She was completely out of it. Twice he told clinic personnel, "I didn't do anything to her." The examining physician could find nothing wrong with her. A urine toxicology screen revealed that there were no drugs in her system. The screen would not have revealed the presence of Benadryl, however. The husband told the doctor that while sleepwalking, she might have taken Benadryl and codeine. She could remember nothing of the incident the next day, but she believed it was her fault. She had overdosed on her allergy medicine, Benadryl, and herbal dye pills. She wanted to lose weight before her daughter's wedding. Her excess weight and her husband's consequent disapproval also concerned her. She once remarked, "As soon as I lose weight, he is going to take me on a cruise." During the month of April, in addition to the searches on household accidents, the church computer was also used to explore details about prescription drugs. An online search engine was engaged to look for such medical medicines as lorazepam, Activan, Ambien, and TSA. Various web pages were downloaded from drug manufacturers and other sites, all describing these drugs, their purposes, and their dangers. Although the date could not be isolated, one of the searchers brought up a website promoting a book entitled Worst Pills, Best Pills, a consumer's guide in avoiding drug induced death or illness. Listed among the 160 do not use prescriptions was medication called tamazepam. Okay. Mm. Literature warned that this medication carries dangerous consequences if taken improperly. Overdose symptoms included confusion with reduced or absent reflexes, respiratory depression, apnea, hypotension, impaired coordination, slurred speech, seizures, and ultimately coma and death. This last internet drug search that month was on April the 27th. 2 days later, in April 29th of 1999, the husband went to the clinic complaining of insomnia. He saw a physician assistant. They discussed sleeping medications. She suggested Ambien. He declined, saying that both Ambien and Xanax had not been effective in the past. His medical records, going back 10 years, mentioned nothing of past sleeping problems or any prescriptions for sleeping medications. They agreed on the temazepam, although Thompson had reservations about prescribing it because of its side effects. And after all, he was an old fuck. I added that. One side effect is residue drowsiness, and the day after the medication is taken, the husband received a prescription for 15 capsules at 30 milligrams strength with 3 refills. He was to take one capsule at bedtime. Later that day, his wife reported to the doctor that her husband said he had lost his prescription and asked if she would mind calling a second one in for him. The doctor phoned the prescription in at the drugstore. The husband went to Kmart that afternoon and had one prescription filled. 2 hours later, he went to the other drugstore and had the other filled. On May 4th, the church computer was again used to search the internet, this time specifically for that drug. And on May 12th, his wife picked up a refill of the drug at the drugstore. The next day before she drowned, the husband picked up yet another refill at Kmart. Now 60 capsules had been obtained in a period of 2 weeks. One of his wife's favorite drinks was chocolate milk. She drank it every day and usually in the morning because the drug comes in capsules. These contents can be removed by simply twisting them open. The powdery substance inside is tasteless and odorless. The um, the other sleep remedies that the physician assistant had discussed with the husband, Ambien and Xanax, came in tablets form and thus cannot be easily dissolved, especially in chocolate milk. When the pathologist examined the contents of her stomach, he thought it unusual that there were no Tamazil pills to be found. He found pieces of other medications and non toxic amounts. Law enforcement officers theorized that the contents of approximately 20 capsules had been placed in her chocolate milk before she drank it that morning. She would not have been able to detect it, but her death, a friend who came to clean the home, wiped up what she thought was flour on the kitchen counter. The wife was allergic to flour, but flour was stored in the home. There was still chocolate milk cartons in the refrigerator. After the wife's death, the husband gave conflicting accounts of the drowning. The version he reported to the deputy is not the one he told the daughter. She didn't recall her father giving her this information. In her presence, she claimed to have gotten the wife out of the tub himself and then called 911. Did you hear that? In the daughter's presence, he claimed to have gotten his wife out of the tub himself and then called 911. The brother, the brother of the wife, recalled that when he was with the husband at home after his sister's death, he heard the husband explain the circumstances surrounding his sister's death several times, and each time the details changed. He said that the pastor also said that the husband told him that the night before his wife's death, she had awakened around midnight because she was sleepwalking. The husband went over to the church to work on his sermon. He returned an hour later to find water running out of the bathroom and down the stairs. He ran up to the bathroom and found her. The husband told someone that he tried to resuscitate her, but he told the deputy on the case that he did not even know CPR. The deputy thought it was strange also that right after his wife's death, he told him, "We were getting along great." He had previously told everyone else that he wanted a divorce. The state's case. The husband was indicted for first-degree murder on August the 27th. 3 days later, he appealed the arraignment and was ordered held without bond. He pleaded not guilty. Jury trial commenced on January 10th. Whether his wife's death was murder or suicide was a crucial issue. And that is also the issue in this case. The state called various witnesses, including law enforcement, doctors, and computer specialists, the pastor over the church, and the three daughters on the question of suicide. The state offered a clinical psychologist, sociologist, and the executive director of the American Association. They explained in an expert who, through professional training and experience, studies primarily in terms of learning about the character of the individuals who are suicidal and those that do commit. He objected, arguing that the theories were not scientifically valid. Some of these things I am keeping off because it is a little taboo. A little taboo. All right. The wife exhibited a minimum of predisposing risk factors. Although she had ingested multiple drugs, a circumstance consistent with the S word, she had no history of mental illness, depression, significant physical illness, chemical dependency, or any other adulation. She had no personal or family background of this behavior. Her husband had been having an affair, but she almost certainly had known of it for some time. The husband later admitted on the stand that he had told her he wanted a divorce the previous January. With her knowledge of her husband's infidelity and plans of divorce, they believed that those circumstances could not likely be credited with triggering that's word. The wife was excited about her daughter's upcoming wedding, but with her personality and her self consciousness about her weight, she would not want it to be found naked. The S note. After the state rested, the defense counsel unveiled an S note. The husband had given it to his attorney in mid June, some 7 months earlier, despite a discovery order. Counsel did not disclose the note because, as he explained to the judge the next day, it had been given to him in confidence and he was not authorized to release it at the time when he received it. Counsel believed the document was absent of authentication, and particularly the elimination of the client's source of the document. It did not occur to counsel to have the note examined for fingerprints until he read a newspaper article in the Madison Daily Leader in late December of 1999 about someone's locally operated fingerprint business. Over the state objection, the note was admitted, subject to state experts having an opportunity to examine it and hearing following the trial on possible sanctions against the counsel. The husband took the stand for the limited purpose of explaining how he found the note. He said he discovered it in his church office on June 10th, 3 weeks after his wife had drowned. It was written by his wife, he said, and placed in a book that Sharon, oops, I said her name. Sorry, y'all. I used for preparing bulletins. The husband told no one but his attorneys and a fellow minister in confidence. Y'all, this is fun. I'm hoping y'all are having fun with this. 5 days after finding it, he gave it to the defense counsel. He never mentioned it to his family or to law enforcement investigators. In fact, in July 26th, his wife went to her father with a hidden tape recorder, seeking answers from her mother's death. The daughter, I'm sorry, the daughter went to her father with a hidden tape recorder, seeking answers about her mother's death. She broached the subject of the escort, but the husband volunteered nothing. He appeared nervous and would not make eye contact with her. 2 days later, however, he came to her workplace. He then revealed to her that he had told the mom the evening before her passing that he had told her about the affair and that he was going to divorce her. The wife responded with an anxiety attack, according to the husband, and thus he was suspicious that her death the next morning was the escort. Yet the daughter recalled telephoning her mother that same night after 10 to ask about a glue pot she left at church. The wife was in bed at the time. She agreed to bring the glue over the next morning. The daughter detected no stress or emotional upset in her mother's voice. The unsigned note was dated the day before the wife's death. It was addressed to her daughter, dated May 13, 1999. Dear daughter, I am sorry I ruined your wedding. Your dad told me about your concerns of my interfering and the possibility I might ruin hers. I won't be there, so put your mind at ease. You will understand after the wedding is done. Love you, mom. 5 days before the trial, the defense hired someone to examine the note for fingerprints. The wife had no prints on file, so they took the. Wait a minute, I'm trying to make sure I keep names out of this. There were 4 prints on the S note. They had no record of the wife's fingerprint on file. The S note, when examined, did not have the fingerprints of the husband, of one of the daughters, of the mother, but one of the sisters refused to supply her fingerprints. To prove the note was not written by the husband, the defense called a computer specialist who testified that in his examination of the contents of the church computer's hard drive, there were no traces of any such note ever being created. However, prosecutors were reminded that there was a second computer. It had been in their home when officers had earlier examined the home in July with the search warrant. They saw the computer, but it appeared not to have been used. They decided not to take it. The husband had access to it until he was arrested and jailed on August the 27th. Sometime after his arrest, he asked his daughter and son-in-law to store some of his household belongings, including that computer and the printer connected to it. Now, on the revelation of an S note, the state asked them to bring in the computer. They agreed. The husband moved to suppress the evidence gained from this computer, asserting that it was seized illegally. And of course, the court denied that motion. After examining the home computer's hard drive, the state expert found a document with conspicuous similarities to the note that the husband gave his attorney. This document had been created and modified on the 7th of August, like the document portrayed to the jury as the wife's S note. It was dated May 13th. The font appeared similar, and the margin size and spacing between words appeared identical. Even the lack of a space in the date between the comma and 1999. But there were also differences. Body of the note was missing. Only the date and the words, "I love you, Mom," remained, but without the all in the line. And nevertheless, based on his examination of the document's electronic background data and the similarities between the note the husband gave to his attorney and the document found on a home computer, the state experts concluded that the August 7th document was the predecessor of the purported note. According to the experts, additional lines could have been added, printed out on the computer, and then turned off, and no record on a hard disk had remained of the added lines. When recalled to the stand to answer whether he created that document, the husband testified, "I probably did, but I didn't. But I don't. 3/4, I don't remember it." Even so, he insisted that he did not create that S note he found on June 10th to confirm that the note existed before August 7th. The attorney testified that he saw the note quite a while before July. Still another note threatening the S was found on the home computer's hard drive with the wife again as a purported author. It listed various grievances that she was addressing about her husband. One line stated, "I'm upset that you had an affair and you have not come clean with me. I have thought of my life and you would have to face up to it. Believe me, I've known how to do it." According to the state's expert, this document was created on August the 11th. The husband admitted that he wrote this one, but merely as his way of working through the emotional trauma of his wife's death, to try to bring some reason into what had happened. Although this examination was complete after they analyzed the S-note for prints in early January, she thought that with added time, the prints might become more distinct. After all, there had been many people who had touched it. Verdict and appeal. After 2 weeks of trial and 5 hours of deliberation, jury found the husband guilty of murder in the first degree. He was sentenced to mandatory life in prison. He appeals his convictions on the following issues. Number one, whether expert testimony was properly allowed in the question of the yes. Number two, whether the motion of judgment of acquittal was properly denied. Number three, whether the circuit court properly denied a defense motion to suppress evidence obtained during trial. And number four, whether he was entitled to offer subbutal testimony in his from the fingerprint expert. And number five, whether certain communications by the husband to his superior fell under the clergy privilege. Number six, whether the circuit court properly allowed the state to play the tape recorder conversation, have the jury read a transcript of this recording, and permit live testimony regarding the same conversation. Here's your mission. Given the information that you have, did he or did he not commit this crime? There are two sisters who are currently in dispute over this ruling by the courts. One sister indicates that she has documentation proving that her mother was depressed. That was never entered into court. Why it wasn't entered, I don't know. But the sister indicates that it was never entered into court. The other sister is the one who worked with the prosecuting office. She wear wire to try to frame her father. Not frame him, but just try to get him to tell the truth. Okay? Daddy, just tell me what you did. Did you or did you not? These sisters have been in dispute over this for 15 years. We are here, the court of opinion, to see which sister is right and which sister is wrong. Please join me on Monday, September 21st, on Auntie's Advice Channel for Women, where we will discuss the sisters' issues, their disputes with each other, and we, Auntie's Advice nieces and nephews, will let them know who is right and who is wrong. Thank you for joining me. If you were not able to make the live, please feel free to listen to the replay. This is being played on Auntie's Advice Channel for Women and Auntie's Advice, so that you all will know what's going on Auntie's Advice Channel for Women. Please join us as we solve this mystery. Love you and have a great day.